Welcome to the Top Talent and Immigration Show with your host, Kaushik Ranchod. In this show, we discuss how companies and top talent in America overcome immigration obstacles and help create freedom and prosperity in America.
Kaushik Ranchod here. I'm the founder of Top Talent and Immigration, where I talk with leading researchers, business leaders, and attorneys on how they overcome big challenges in the immigration process and business. This episode is brought to you by Ranchod Law Group. Ranchod Law Group's mission is to provide freedom and prosperity for immigrants and help more businesses to connect to top talent. Ranchod Law Group believes that immigrants add tremendous value to the U.S. economy and helps companies facing a shortage of talent to make up that gap and grow thanks to the immigrant talent that contribute to their bottom line. They also help immigrants to navigate the complicated immigration process today. Ranchod Law Group has been in business for nearly 20 years in Northern California and serves clients nationwide as a trusted advisor for employers and helping employers to attract talented immigration employees. Contact Ranchod Law Group today for details on how the firm can help you to solve your immigration challenges. Visit us at ranchodlaw.com or 916-613-3553. All right, so today it's going to be me talking about J1 Waivers, some case studies of cases where we got approved. And I just want to share with you what's currently happening right now with the J1 Waivers. We had a lot of J1 Waivers for physicians and researchers and scientists. And today I'm going to share our most recent success story. And this one was a huge success for us because the couple was from Canada, or the family was from Canada. So we didn't have country conditions like we do with the other J1 waivers to argue. But there are some other factors here that we were able to argue and make a case out of. And one of those was that the client was a specialist and she was pregnant with her first child. And that's when she initially contacted us. She was initially pregnant, and her U.S. citizen husband and parents, we argued, would suffer exceptional hardship if she had to return to her home country, because one of the reasons is because of what we call career disruption. He was also a specialist as well, and he is also board certified. So his whole career would have been disrupted. He spent 14 years in education and training, and he would not be able to initially practice in Canada. So that was a very strong argument that we made. And then we also made an argument of mental health issues, because he had a history of mental health issues, including general anxiety. So that was another area that we were able to focus on as well. And then the other issue was that his wife would not be able to go back to Canada to be a single mother with their child. He wouldn't be able to remain in the United States separated from his wife and child, and he didn't want to be separated, and he didn't want to send his wife to be all alone and by herself. The other strong argument we were able to make is that our client is one among the severe shortage of medical specialists. And current wait times to be seen by the specialist is over 11 months. Now, because of her J1 waiver approval, our client can continue to help the vulnerable population that she serves. So that was one for Canada, and that was just very recent that we got this one approved. Now, I'm also going to share a case study of a client who is an Egyptian national, and they had two U.S. citizens, and one of the children had a medical history of respiratory illness, and the child also receives medical care multiple times each year. So that we were able to here argue medical hardship based off of these factors. And in the U.S., they have excellent health insurance coverage through the employer, but they would lose that if they had to relocate to Egypt. So we were able to argue exceptional hardship here because of also the country conditions in Egypt, especially the pollution in Egypt. If anyone's ever been to Egypt, or if you're from Egypt, you know that the pollutions are horrible and would aggravate the child's health. And this is also backed up. We also backed this up with documentation as well about the pollution and other country conditions of Egypt, such as the terrorism and kidnapping, the severe educational deficiencies in Egypt, and then the language barrier the children would face, and the emotional mental hardship to the children as well. And not to mention financial hardship. So one point here that I want to make in describing these two case studies is it's very unique to everyone's situation. So it's really important that you consult with an attorney before filing to see if you would qualify, because although these were approved, it really was very specific upon the facts and how those facts are weaved in to demonstrate exceptional hardship. And then two, it's also really important to note that you have to demonstrate the hardship to the U.S. citizen child or spouse or permanent resident spouse or child. That is the qualifying relative. And the standard is exceptional hardship. Another important point here to make is that you have to demonstrate hardship if there's separation or if the whole family, the qualifying relative and the applicant both go back to the home country. And a lot of times what I see failures in individuals who hire someone who's not as experienced in filing J1 waiver applications, or when they do it on their own, is they miss that aspect of the case when filing. All right, well, that is going to be it today. Want to thank you so much for tuning in. And if you have questions, as always, give us a call, 916-613-3553, or visit us at ranchodlaw.com. Thank you, and talk to you next week. Bye.
Thanks for listening. Be sure to click to subscribe, check us out on the web, and we will see you next time.